In the few moments that I have allocated to be able to talk to you about this program that took over a decade to sort of get implemented, I'll try to condense it down into 8 minutes and give you a flavor of what the program is, how we adopted it, why we adopted it, and a little bit of that process. As we all know, and it's been commented many times during this session, and we all know it very, very well, we do have a significant access to justice problem. I, as a professional, a lawyer, am embarrassed that we have this problem. And we hold the keys to the solution to the problem. We really have two problems, I think, in our state and all across the country. We have an access to justice problem, and we have a consumer protection problem. We charge too much money. Consumers cannot afford us. We need to find a solution to that problem. And consumers often don't know where to go. I spent nearly 20 years dealing with issues related to the unauthorized practice of law, and it's always been enforcement, enforcement, enforcement. And frankly, I don't believe that's the solution. I think providing an alternative so that those people who do go to people who are delivering services that are otherwise known as UPL, I think need to have an alternative, and that's what I think this program is all about. I'm going to give you a little bit of that history before we get to the court order. Back in around 2002, we realized that there was a problem. The Supreme Court commissioned the Civil Legal Needs Study, quantified what the problem was. We realized that what we all know, more than 80% of people in our states do not have access to the legal system. And again, our approach in our state was to talk about UPL, and on that note, the idea was to take away this unqualified, unregulated service provider. But the idea was, if we do, we still have an access to justice problem. And so our court at that point said, let's find a way to create another form of legal service provider. And so they gave a commission that they created the task of coming back with a proposed rule in which non-lawyers could engage in the limited practice of law. It took about 6 years for us to develop a proposed rule. We looked around the country and didn't find one that we thought the Supreme Court was looking for, and so we created one, what we thought was out of whole cloth. We made a couple of presentations to the Board of Governors from the Washington State Bar Association, and as you might imagine, they were not amused. They voted against the proposed rule twice, 13-1 the first time and 12-2 the second. So we were making progress, we felt. And then finally, after many talks and many speeches around the state, the Supreme Court in 2012, I felt courageously and wisely, adopted the proposed rule. And I'm going to read from the rule, the order that adopted the rule, and Chief Justice Madsen is here in the audience, and she authored that order. And I think she did an excellent job of capturing the essence of why this rule was created. She said, we have a duty to ensure the public can access affordable, legal, and law-related services, and that they are not left to fall prey to the perils of the unregulated marketplace. And I think they did an excellent job of capturing the work that had been ongoing for a decade at that point. We chose as our first practice area to which the rule would be applied as family law. Some of you may know the rule is designed to be applied to any number of practice areas. We are in the process of considering an additional practice area. Those are under consideration at this point. Could be, and I'm not speaking for the board and certainly not the court, could be immigration, landlord-tenant, elder law, and a number of others. Some of the requirements for the LLT, and one of the concerns that was expressed as we were proposing the rule, one of the criticisms of the rule was, gee, it looks to me like you're creating a whole new bar association. And the answer is, indeed, we are. And the mission was to serve and protect the public. We wanted to make sure that these licensed legal service providers, and I want to clarify, the rule that the Supreme Court adopted, this suggested the rule should consider non-lawyers delivering legal services. I believe now they are licensed lawyers delivering legal services in a limited capacity. So these are some of the requirements. I'm not going to go through all of them, but I will identify a couple of them. The education requirement is really one that was really fun and exciting. We brought together the collaboration between the law schools and the community college system in our state. We have two different levels of, education. One is the core courses, which are necessary for anybody who's going to be a triple LT. That's the shortened version. If anybody has a better term for limited licensed legal technician, I'd be happy to hear it. And then the collaboration between the among the law schools. And the law schools came together and created the curriculum. Once we picked the area of family law, we limited the scope. We brought in experts in the area of family law and said, how would you limit the scope so that adequate services could be delivered to the consuming public in a way that would meet their unmet need, and yet do so in a way that would not in any way jeopardize the public? Law schools did an amazing job of developing a curriculum. The curriculum in the area of family law is designed to give triple LT students 1 year in law school. After we developed the curriculum, again, which was helped to develop by the law school professors from the 3 law schools, one of the law school professors was heard to say, you know, I actually believe that triple LTs delivering services in the area of family law are probably going to be better qualified than JDs coming out of law school, because they will have taken a full year of family law courses in law school, whereas most of us going to law school maybe even never take a course in family law. One of the other things that I think is unique is triple LTs, again, to serve and protect the public, are required to show financial responsibility. I believe Oregon is the only state that requires lawyers to have malpractice insurance, and I think we all should be having malpractice insurance as well. You can see at the bottom, triple LTs have their own rules of professional conduct, and they're subject to discipline in the same way as lawyers. The business models that we've considered are that triple LTs, as you may know, can be freestanding. They can practice on their own, and they can also practice in conjunction with law firms. As you can see here, triple LTs also can have a business interest in a law firm, which is a bit revolutionary, I think, in our country. The other thing that they can do, and I think this is going to be really exciting, is that they, I think, will be providing services in the area of legal services. And in fact, in my own county, I just learned this last week, our volunteer legal service provider is considering hiring a triple LT to enhance the services that are delivered to people who can't access the family law system. And our judiciary is deciding to hire a triple LT to assist them in managing family law cases in our trial court. So this whole thing, as we all know, is about access to justice. And I'm going to leave you with a quote that I often leave an audience, much more hostile than you are, I hope. And I challenged them with this, and I know you've all heard this, but it seems apropos, certainly in my presentations and hopefully to you. If not this, then what? And if not now, then when? Thank you.